Be ready. 5 seconds. Start. The appellant was tried with 4 others and was convicted under sections 394, 460 and 302 read with section 34 of the Indian Penal Code 1860. Stop. He was also found guilty of offences under sections 11 and 13. Stop. The appellant was in fact sentenced to death for the offence under section 302 read with section 34 of the IPC along with 2 other accused apart from a fine of rupees 5,000. Stop. He was sentenced to 10 years rigorous imprisonment in regard to the offence under section 460 of the IPC. Stop. He was also handed down a sentence of 10 years for the offence under section 394 read with section 34 of the IPC. Stop. Still further, he was also sentenced to 7 years for the offences under sections 11 and 13. Stop. By the impugned judgment, the High Court answered the death reference by holding that in the circumstances the death penalty was not warranted. Stop. In place of death penalty, the High Court sentenced the appellant and 2 other accused to life imprisonment and enhanced the fine to rupees 25,000. Stop. The appeal filed by the appellant was dismissed otherwise. Stop. The prosecution case in brief appears to be as follows. Para. On 8 September 2008 in the night, Bharose Lal was at his village. Stop. He was residing alone. Stop. 1. Abhay Sharma, PW9, who is the son of the deceased, was informed by 1. Neeraj that his father has not opened the door on that day. Stop. On receiving such information, PW9, who also turned out to be the complainant, finally went to his father's residence and it was found that his father was dead, and the first information report was lodged on 10 September 2008. Stop. On the basis of the investigation conducted, 5 persons came to be charged with the offences as noticed. Stop. In fact, the appellant was charged under section 397 of the IPC also. Para. PW1 to PW15 were examined as prosecution witnesses. Stop. Material objects were also produced. Stop. The cause of death was found to be shock and hemorrhage due to excessive bleeding caused by multiple wounds. Stop. The death was caused within 36 hours of the post-mortem report. Stop. The post-mortem report was conducted on 10 September 2008. Stop. It cannot be disputed that the death was homicidal and it was caused with the intent to commit murder. Stop. The trial court further proceeded to find that the certain articles were found missing from the almirah in the house where the deceased stayed. Stop. PW8 is wife of the deceased. Stop. PW9, as already noticed, is one of the sons of the deceased. Stop. PW13 held identification of the gold and silver jewelry and the mobile phones which according to them belonged to the deceased. Stop. The identified articles were belonging to the deceased. Stop. 1 necklace, 1 pair of earrings and 2 mobile phones were identified. Stop. The contention of the accused that PW13, who held the identification proceedings, deposed that at that time a police officer was present, was rejected by finding that from the identification memo Exhibit P21, it was clear that no police officer was present at the time of the identification of the proceedings. Stop. The court also relied upon the evidence of PW8 and PW9, who were found to have not stated about the presence of police officers at the time of the identification proceedings. Stop.